Well, the proposed 18th Amendment to the Constitution is probably one of the worst constitutional amendments that has ever been proposed in the post-1978 constitutional history of Sri Lanka. What is sad is that there are tremendous problems both with respect to the process that has been adopted to introduce this amendment and also with respect to substance. It is really quite shocking that the government has decided to introduce this constitutional amendment as an urgent bill, because whenever a bill is introduced as an urgent bill, it means that the normal process of gazetting, of making it known to the public, is completely undermined, and the whole process is couched in secrecy. And indeed, what happened was that on the 30th, after the cabinet approved it, the draft constitutional amendment was sent to the Supreme Court for its opinion as to whether the amendment required, in addition to a two-thirds majority vote in Parliament, also the approval of the people at a referendum. And many civil society groups, including the Center for Policy Alternatives, managed to get copies late in the night. They studied it, and then they had to rush to court the following morning, and with very little preparation, make interventions before the Supreme Court. And indeed, while the proceedings were going on, when the Attorney General was making his submission, we began to realize that we didn't have the final authoritative version of the bill, and we had to ask the Attorney General, while the court proceeding was going on, for a copy of the final version. Introducing a constitutional amendment like that, when a constitution is meant to actually protect the people from those who wield political power, goes against all first principles of constitutionalism and probably goes against constitutional practice that is internationally recognized. So the process by which this amendment has been introduced is hugely problematic. But if you look at the substance of the 18th Amendment to the Constitution, it does several things. The first is that it increases the power of the executive president. And indeed, the whole of Sri Lanka has reached a consensus that the powers of the executive president are too much. And indeed, if you look at Mahinda Chintanaya 1, Mahinda Chintanaya 1 in 2005 promised to abolish the executive presidency. If you look at Mahinda Chintanaya 2, the 2010 version, it promised to reduce the powers of the presidency. It promised to remove the immunity provision which made the president above the law. And it also promised to make the presidency more accountable. This amendment goes against Mahinda Chintanaya 2010 and actually concentrates more power in the office of the executive president, removes the term limit, which is an internationally recognized practice for imposing checks and balances on a president under all presidential systems, and therefore strengthens the presidency. The other feature of the 18th Amendment to the Constitution is that it totally undermines the gains that the people of Sri Lanka were able to achieve through the adoption of the 17th Amendment to the Constitution. It repeals the Constitutional Council, which under the 17th Amendment was responsible for recommending people to several key democratic institutions. It replaces it with an extremely weak, almost powerless parliamentary council consisting of members of parliament, a majority of whom would come from the government. And even they are only entitled to give their observations to the president. The president can totally disregard those observations. The president can basically appoint whoever he or she wants to some of these important institutions. The 18th Amendment also completely reduces the powers of important commissions that were set up under the 17th Amendment to the Constitution. And I'd like to give one example. The Elections Commission, the powers of the Elections Commission are drastically reduced. The Election Commission will not be able to appoint a competent authority to oversee state media if the state media violate the Election Commission guidelines at future elections. The guidelines, the scope of the guidelines that the Election Commission can issue with respect to state resources, the conduct of public servants, police officers, all those powers are removed. And so the Election Commission will become virtually powerless. Another devious and rather sinister feature of the 18th Amendment is that it provides for a kind of acting election commissioner to be appointed until an election commission is constituted. So in other words, it envisages the non-implementation of that part of the 17th Amendment which requires the setting up of an election commission. And so the cumulative effect of the 18th Amendment to the Constitution is to totally undermine the notion of depoliticization and independence of key democratic institutions, and totally undermine the gains that the people of Sri Lanka were able to achieve as a result of the 17th Amendment to the Constitution. So in conclusion, if I might just say what happened in court, a number of people intervened, basically asking the Supreme Court of Sri Lanka to look at this amendment as one that adversely affects the sovereignty of the people, because the franchise and the fundamental rights of the people will be adversely affected by the undermining of the 17th Amendment to the Constitution. The Attorney General came up with an amazing argument that the provisions of the 17th Amendment were merely directory. Many of us countered those arguments, and we basically said that because this amendment was going to undermine key institutions that actually help to realize and give practical effect to the protection of the franchise and fundamental rights, which are part of the sovereignty of the people as per Articles 3 and 4 of our Constitution, we asked the Supreme Court to hold that this amendment could not be passed only with a two-thirds majority vote in Parliament, but also required the approval of the people at a referendum. And I think that the submissions that were made were very persuasive. And now I think the ball is in the court of the Supreme Court of Sri Lanka, and one can only hope that in its determination it will say that a referendum is needed before such a fundamental change to our Constitution that will adversely affect the sovereignty of the people can be introduced.